exception of very few limited issues that are confidential in nature, so I am gonna permit that. Prior to that, sir, I need to have your name if you're the person that's gonna be videotaping.
Cameron Chris Chambers.
Okay,
That's
thank
my
you.
son, Ron.
Okay, and you're videotaping with an iPhone, is that correct?
Yes, ma'am. iPhone 8
Thank you.
plus, if that matters.
Thank you. Okay, so we are before the court this morning for a review hearing. When you were last in court, it was October, when we were here, and I issued an order with respect to the issues presented at that hearing. So we do have limited time today, and I'm going to, how I'd like to conduct the proceeding is to touch on those topics that are scheduled for a review today. I understand, I've read the file, I've looked at the pleadings that have been filed. I understand that there are a number of outstanding issues that need to be addressed, including the relocation, and we're gonna address that today in terms of scheduling it and what needs to happen. And so I wanna start first though, when you were last before me, Ms. Chris, you filed a motion to change the court order with respect to the request from supervised to unsupervised
Correct.
parenting time. I understand that you object to that. On a temporary basis, I issued an order in part asking that you research the availability of Hope for New Hampshire, and whether or not they would be capable of having and entertaining supervised visits there for you and for Brandy Lee. So
May I respond,
yes,
Your Honor?
please.
That was not in the motion. It was told that I was not gonna get any supervised visits at all, and that was based on perjury by Roland and Ann Louise Petria.
Okay, and I've read your response, but it is in the motion, or in the order, in the sense of, I wrote it, and that is my intent, that if, I would like to know whether or not Hope for New Hampshire is
Yes,
a
they can.
possibility.
Yes.
And so, and I know you have your notes there, and I'd like you to take notes of some little, things to jot down that I might need from you kind of going forward. And one would be, I'd like to have something from Hope for New Hampshire that says, yes, we have the, capacity or capability to
They
do
are
this.
state certified,
And
Your
that's what
Honor.
you told me last
Yes.
time, and so my understanding of the last hearing we had is that you would confirm that for the court. I'd like to have something in writing from them. If you could do that, that's
Okay.
something I'd like to know. That's first for you. Sir, with respect to the order that Brandy Lee have some counseling, I understand when we were last before me, and I've read your other orders, you have a request that Brandy Lee have mental health counseling, and in addition to that, potentially counseling with you to address the issues mother-daughter and the, allegation of alienation on dad's part. On your end, sir, I understand that there is a request that I speak with Brandy Lee in camera, and I have your objection to that, and that's something that I've noticed to say, I wanna raise it again to talk about what everyone's position is on that, and then I'm gonna issue an order with respect to my decision on that, or whether or not a guardian ad litem is appropriate in this matter. But at issue first, sir, when we were last here in October, you told the court that Brandy Lee has indicated to you that she doesn't wish to have additional contact with mom. And my response to that is, but that is a significant decision, certainly, and I'm not inclined to issue any orders that would do that without understanding all the pieces, including therapy and having an ability to have a professional weigh in on what is Brandy Lee's, mental status and capacity, and what is in her best interest, to the extent that a professional needs to make that recommendation to the court. That's what I'm looking for. So I understand that you had some trouble contacting the two individuals that did that specific kind of counseling. Yes, sir, please.
Well, I went on the internet. I had found one of the counselors. Now, in your particular motion, it names names,
Yeah.
not the business practice.
Oh,
So I had found, I believe I spoke to Denise out of the Concord facility. She said she wasn't able to start seeing the child until about March.
okay.
And not to mention those facilities that you had actually picked, they do not take healthy kids. they want, the first initial payment, which I do understand, and I restarted the house and forgot my file, but I do believe you had stated that, Mrs. Chris had to pay for,
Do you know what the cost was? Did they quote you some cost of therapy?
no,
Of the session? Okay.
no.
So before I finish,
So I
she
think
has
that-
not gone, is that accurate to date?
Well, we couldn't get her in there,
Okay.
and I couldn't find the other, persons, I believe it was out of Bow.
Okay,
I couldn't find that individual on the internet, so I had filed, so I had called the courts and asked them if they, cause I know you guys have certain things on file. I had spoke to the clerk out there, and she said, the only thing I can say is just file a clarification,
okay,
which I had did, but what had happened was I forgot to put a couple of numbers
I know. I
on
knew
it,
that
and it
happened.
delayed it, and
Okay. All right, thank you.
May I respond?
Yes,
Your Honor?
please.
I object to any doctors chosen unilaterally by the courts because they are always in Roland's favor. He poisons their minds against me every time he goes to any institution, be it a school, a doctor, what have you. And so therefore, I had already put in a motion to have her seen at Manchester Mental Health. They have an adolescent unit, and that is a neutral party, not chosen by the court, and that's where I would like her to go.
Okay, and I saw that, and that was my next question, so thank you. So I know you said, cost is an issue to you, because yes, my
Yes, it
initial
is.
order was saying that I would ask that you pay for it, and I understand that you told the court and that you are on fixed income and in disability, so cost is an issue. And now I have the issue, they can't potentially take her until March, and so your proposal is that she see a therapist. Do you have a name of someone at,
I can get one,
Okay.
I've been a client for over 10 years, and I can get any information that I need to help my case.
Sir, do you have a response or an objection to that? I
Well, I
guess I'd
have
like to
an
have.
objection because I had relocated the family owing to certain issues. But I think it would be best protected for the child to go to seek out. I don't know what kind of credentials you're looking for counselors. I mean, anybody can go see a counselor, but there's
Understood.
certain counselors that the courts require for the counselor's certification to do this kind of process.
Which is specifically why I had made the suggestion in my last order that we find a counselor that has the training and experience specific to the reunification piece. Because what you told me last time is you haven't seen your daughter since April
No,
of 2017.
not last year, April last year.
And so I don't think on the facts that are presented to me that it's necessary to just have a general counselor. I'm concerned about the cost because I want it to be something we can attain for the best interest of Brandy Lee. And my goal is to not set the parties up or Brandy Lee up in the sense that I'm ordering something that we can't make happen. I need to have evidence in front of me of what is in her best interest, so it will help me make a decision in this case. And so I'm not sure what we have at Manchester Mental Health, if
They
cost
have a whole
is easier there.
adolescent unit, and I do believe that they take healthy kids, they treat half of Manchester.
So maybe that's something we can look some more into, if there's anybody there that potentially would be qualified. I know that in the past when Brandy Lee was here, when was the last time she was in counseling, any individual or otherwise? I know she was seen, it was at Riverbend for a period of time, that was some time
Yes.
ago, but.
Yes, that was quite many years ago. I believe it was, she's had many series of counseling sessions. It was Riverbend, it was DCYS, because all these
Yeah.
allegations, the child has virtually been thrown in all kinds of stuff. But I know Riverbend was pretty much the only one that I really recognized.
Okay, and now talk to me, I'm gonna hear first from him, and I know you have an objection, I'm gonna wanna hear from you on a couple more things. One, you've asked this court to bring in Brandy Lee. You've argued in your petitions that you filed that she's now age 14, and you're asked the court to speak with her in camera. Is that a continuing request that you have, and if so, I'd like you to, you know, you can present any other evidence on that, and then I'm gonna hear from you, ma'am, on your, if you object to that, and, you know, the basis for that, okay?
Well, I think it's just not starting today because she don't wanna see her. I think it's the long duration of the 13 years of being tossed around because the severity of the mental health issue that the petitioner exposes has that and a very serious violent history has exposed it. The courts had given the petitioner over the years the time and the days and the visits, and they were constantly erupted by the petitioner's behaviors. In fact, the most recent was with the Nashua Visitation Center. And this is just not a case, a new case to the court with new judges and new faces. It's a long history here. And virtually, I would have to say out of the 13 years, now we're going on 14, that the child really virtually probably had maybe about 3 years of visits. This is starting at age 7 months. But the child, since the last abrupt disturbance, she virtually don't want to see her anymore. And that's not my position to state that. You know, she has her own reason, thoughts, and opinions. And it's not, and I understand that you want professional counsels involved to dictate on why does this child think like that, you know, and the realistics of the case. But I do know recently she had, the petitioner had filed, her birthday was on January 16th, and
You
a
can be
motion
seated. You
before,
don't have to
a
stand.
motion before the court to speak to Brandy Lee on January 16th. Now, I think the court needs to understand that. I am the responsible parent in this case, but if I tell the child that your mother called and you need to call her, and she doesn't want to, where am I left? Now
That's something that-
she's trying to say that I'm trying to alienate the child, but realistically, the petitioner is not realizing that her behaviors over the years has affected this case.
I understand that, sir, but that's a concern the court has with respect to, you know, she's still young, and 14, you know, it's not 4 anymore, but she's still a child, and our statutes, 461A, tell this court that there's a presumption that children do best when they have both parents in their lives. And so it's something that I do take serious insofar as, and I've read your pleadings that you say you feel like you're between a rock and a hard place. So what I'm looking for is some guidance to what needs to happen here with respect to your daughter and contact and what it's gonna look like. And we're gonna talk about the relocation in a second because that adds a kink to all of this that we need to address. But before I talk generally about kind of scheduling and the relocation issue, sir, ma'am, he's asked in the past in a formal written pleading, and I think you've raised it again, that I ask that I speak with your daughter in chambers and or in a court proceeding without the parties present. And so I believe in the past you've objected, and I know that through
I
counsel.
still do.
Yes, and that's what I wanna hear from you, just your position on that, so I'm clear.
On 12/18/15, I submitted into this court every single law that Roland was breaking pertaining to interference with visitation. Okay, I've been supervised for the past 10 years. Had I been appropriate or Brandy not want to see me, that would have came to light a long time ago. I went from a loving relationship with her to her not wanting to see me, writing a goodbye letter. I can prove alienation in this case. Any gaps in my visitation were due to Roland's interference with my parenting time and certain individuals of the court as well.
Okay, so I understand that's your position, and I know that you've got pleadings in essence or motions with respect to that, but specifically, I just wanna be clear, you object to the court having an in-camera?
Yes,
Okay.
judges aren't psychiatrists, there's severe alienation in this case. This child has a lot of trouble because she's been brainwashed, and she's gonna need professional help.
How do you propose that the court hear from Brandy Lee if she doesn't have a reunification counselor and the court doesn't meet with her? Do you have a proposal for how I consider what her best interests are?
Well, so how about a CASA advocate? I don't want any more guardian ad litems, they've interfered with this case enough, and a CASA advocate would be great.
It would be, except in a marital case like this, they're available in guardianships and abuse and neglect, but I don't have the ability to appoint CASA. I only have the ability to appoint a guardian ad litem, and the problem is, since you were last here, or had a guardian ad litem appointed, I no longer have a fund. So in the past, we had a state fund that would provide for it if you didn't have, parties didn't have the ability to pay. At this point, it was eliminated, I think, in 2011, and so it's private pay. There might be some sliding scale on things that we do, and I understand, I've looked at the file, that there've been new 4 GALs, Cantor, Sternberg, Attorney Griffin, most recently.
Judith Roman was the first.
Judy Roman.
2
So-
for me, 2
And
against
some of those
me,
people
1
are retired
recused.
now,
Your Honor,
I know that.
I'm sorry to interrupt. I feel like if I could just weigh in on this particular issue for 1 second, I feel like my mother could agree and we could find a compromise here just from this one notation.
Okay, I guess let me just stop, ma'am, do you want him to
Sure,
address
sure.
me?
Thank
Okay.
you. Roland obviously wants Brandy to speak with you in her chambers. My mother objects to it because she feels the alienation has caused my sister to have a negative, if not completely deplorable view of her due to Roland's alienation. If my sister could be asked, I'm not saying a loaded set of questions, but an agreeable upon set of questions upon both parents in a particular sense of how much does she really know about her mother. I feel like in your wisdom as a judge, these certain questions will give you the answers you need to see what the child actually feels like towards my mother. As my mother stated, we had 10 years of visits with absolutely no issues. We found out there was an issue, we called the visitation out on them, suddenly there's issues.
Okay.
My sister and I, again, there were issues in one incident where Roland had given us 2 hours unsupervised visits. We were allowed to go out with my sister. There was a 2-minute incident where a car got switched because I had started a new job. And we went back to the visitation center. Suddenly it was back on 1-hour visits. And also, again, if I could just address, towards the end of the last court case when you were here, your ruling was that we went back to the original court case at the visitation center, which was an hour 2 Sundays a month. As soon as we got back there, Roland cut that to one day a month for 2 hours. But
That
I'm
must
just saying it
have
was
been
against the original ruling.
Judge Chabot's, because by the time I have been, and you've been in front of me, there was the termination from Nashua, which is no longer now even taking people, so that's why I ask about Hope for New Hampshire. Okay,
I just wanted to add to what he
Yeah.
was
well,
saying. I think,
with respect to the questions, I mean, prior incidents, that is what it is. I am somewhat drawing a line in the sand of, I'm moving forward right now to get a sense of what are the steps that we need to take with respect to the issues that are pending. You have a pending motion to have unsupervised contact. And if that's not feasible, then supervise, but where? And then you have an objection to the relocation. So I wanna hear if your response, sir, to this idea that there could be a list of questions, whether it was something that the court explored with her, or a guardian ad litem, or, you know, a qualified therapist, and how we would do that. You know, could we do that at another hearing where we exchanged some questions and we had, you know, argument and or discussion over what would be appropriate or not. Let me just hear from him quickly, ma'am, and then I'll come back to you. Go ahead.
Yeah, just to get, just to start back a little bit on the relocation, I guess the great fear and just the nature and the history of this case had put us on edge because as I had stated to this court, we got 6 children involved. And
But the only child
there's a
that's
lot more.
before me is Brandy Lee, sir, and I understand you have other children.
Yes, I understand, but I have a whole slew of family.
Right,
with-
and that
with-
may be a factor for the relocation, which I'm gonna talk about
I'm
in a
not
minute.
using that for an excuse, you know.
Talk to me about the idea of the questions. Mom's concern is that if Brandy Lee comes in and just says to me, I don't wanna see mom, that I will accept that as true. Which, I'm gonna say, even if I ruled that, this court has judgment to understand that children say lots of things, which is why I'm not making a decision at this point of whether or not I think it's appropriate under the statute or her age or her maturity, but I'd like some background on that to determine even if it is. But regardless of what she tells me, yes, I do, no, I don't, then what? I mean, that's the next step in all of this that we have to talk about. So talk to me
I guess,
just
well,
briefly about that.
the only way I can try to convince the court or direct the court into traveling and, you know, try to self-navigate this is that since I have relocated, it had put a kink in it, okay? So the petitioner's naming off these places where she has contact with. I don't think it's great facilities. I said, but that's one issue. The other issue is the insurance. So she fails to want to pay for anything for the child, okay? So now the child has state insurance to where we live. I would recommend, I don't know what kind of credential counselor you're looking for. Maybe you can implement it on that or let me know someplace, of what kind of counselor I need to research for. Out there, she will be covered, she will receive it, and the courts will receive the documents.
Okay, so here's the, did you wanna
Yes, I
add
did want to
something?
respond. Roland alleges that it's my violent behavior and my mental illness that caused the separation, and it was really him. And I'd like to produce its evidence, a police report, because this case started with domestic violence of Roland assaulting me with Brandy Lee in my arms.
I'm not gonna take my guess is that could even be part of the file
It
from
is.
prior, so I don't need another
But
one.
it's never been recognized, it's always on me. I've been financially responsible for mostly everything in this case, even though his income is twice of mine. He has not put in a financial disclosure since two
I
thousand
know,
and
and
five.
that's a separate issue with the child support that I've said, if we need to review the child support, that's been more than 3 years, that would be scheduled in
Well,
front of
I
child
have
support
right
referee.
here
But-
that he was notified in 2015 and 2017 that he was supposed to put one in.
I don't wanna get off track, cause I have I'm already 5 minutes over, so the last thing that we need to address is this.
And he
You
wasn't
have-
supposed to move.
You've relocated without court permission in sense, sir. So you, by statute, you're required to notify Ms. Chris of your intent to relocate. And then she has the right to object, which she's done. So I understand that you are now temporarily in Indiana, but I need you to understand this process. Until this court grants your request and says and makes a finding that it's in your daughter's best interest, it's temporary in the sense of, I may make a finding that it's not in her best interest to relocate to Indiana, in which case the order could potentially require you to return with your daughter. And so you've moved, you are temporarily there, I have your objection, so now she's entitled to a hearing on that relocation, and we will have a hearing on that. At that hearing, we'll get into this further down the line. The burden is first on you, sir, to prove to this court that your reason for moving was a legitimate purpose to move, and that the location that you chose is appropriate in light of that reason. And then, if you meet that burden, the burden then shifts to you, ma'am, to argue and prove to the court that it's not in your daughter's best interest to relocate to Indiana. That is a separate issue. Obviously, I'm not gonna address it today, and when I said in my review hearing of January 23rd of what we are going to address, I know you don't wanna be before the court, and I think you've said in one of your pleadings that you'd prefer not to you'd like resolution in this, but at this point, those items that are outstanding are your petition, and I'm not talking about the other motions, but the big substantive issues that are for this court to determine are whether or not I modify the 09 parenting order with respect to supervision, and then in addition to that is your request now to relocate with your daughter. And so I want you to understand, and I will follow up with an order that kind of outlines either some of my decisions in this case, but where I expect to move forward in sense of scheduling and things, but New Hampshire is gonna retain jurisdiction of this case, sir, both of the child support and the parenting. I understand you are there temporarily, but I want you to understand that this court has jurisdiction over your daughter. She lives here. This matter was pending at the time that you chose to relocate, and so, you need to understand that, Ms. Chris has, filed an objection, and she has the right to a hearing, and so.
Well, I know, at the time that I did relocate, she virtually got suspended, I believe it's in April. And
that-
we had moved out there in May,
When
the
you were in
first
front
week
of
of
me in
May.
October, sir, you
And
didn't tell me
then
that.
they issued a hearing. So,
Okay,
this was before all these hearings got started.
so I need to wrap up today, because now it's 9:37, and I'm late on my 9:30 hearing that we have. But
I still have several issues before the
Okay.
court that haven't been ruled on.
I understand that, and I'm going to issue an order ruling on the outstanding motions. Ma'am, you have a copy of the orders, or I'm sorry, the motions, and you're gonna provide those today to
Yes,
Mr.
I can provide them to him right now.
So,
Here you go.
these are a number of pleadings that she's filed with the court. The court has not ruled on them in part, ma'am, because everyone has the right to notice. Our Constitution says you have the right to notice and the opportunity to be heard. And my goal in all of this is fairness, in the sense of, when we come to court, I expect everyone's gonna know what the issue is. They're gonna have had an opportunity to look at the pleadings and consult with counsel if that's what they wanna do. And so, today, she's handed you some motions that I have before the court that I've not ruled on. You have 10 days. To the extent that you want to respond, you may, and you can file those with the court. Going forward, if you file motions with the court, we need to, at the same time, mail them, so you have a copy, and then in that time frame, and same thing. I know I've looked at the court, there have
I
been.
have proof that I mailed all
I
the
know
other
you have.
ones.
There have been issues of both of you raising contempt with respect to, alleging that you don't get that. I don't want that to happen, and I wanna be clear, this is about notice, opportunity to be heard, and fairness. So when we come to court, it will be on those issues that, that you've noticed each other, and if the court hasn't ruled in writing on something, and I say we're gonna have a hearing, we'll all know what it's gonna be for, okay? Yes.
Also, can I add to that, I guess the new pattern with the petitioner is to file emergency hearings every, once, two times a week, I think. And then she would leave like these, long nasty voicemail messages.
What's just briefly before we go, what's the status of the telephone contact
None.
with Brandy Lee?
Far as what?
Well, I didn't.
I know
is there-
she had filed an emergency.
Well, that was for her birthday,
Hearing
because
for
I do
her
think
I
that
got
birthday.
to
was,
speak
What?
to her.
that
Your
was
Honor.
important, that she has the
What can I
opportunity.
do? If I tell the child she's at 14, she's old enough to say, I don't wanna talk to her.
Does your daughter email?
No.
I'm gonna,
She does have a Chromebook through the school. What her email address is, I don't know, but
well, I don't know about school email,
I
whether or
mean-
not
Not
that's
approved.
necessarily appropriate, so. All right, so I'm gonna take the matters under advisement that we talked about. I will issue an order. I want you to understand, that's an order with respect to scheduling and what the next steps are gonna be. But we will come back, whether it's for a pretrial conference or some other issues that I make, and we will address that as far as scheduling and how we proceed, okay? All right, thank you very much.